All right, good morning, everyone. We're back on the record on KCR 22-21-1623. We are continuing with voir dire of juror groups this morning. Is the state ready to proceed?
Yes, Your Honor. Thank you.
Is the defense ready to proceed?
Yes, Your Honor. Thanks.
Okay, thank you. Counsel, out of this group, I'll note we are advised there are two fell to appears, jurors 262 and 233. Will advise if they do show up, but shortly here we'll have these jurors brought in and do a roll call to confirm. All right, parties are ready. I'll ask if the bailiff instructs the jurors to be brought into the courtroom.
All right, please. Stand up, Your Honor.
Thank you. Please be seated. All right, good morning, ladies and gentlemen of the jury. We are on the record on case CR 2221-1623, State of Idaho versus Chad Daybell. I'll note that the defendant is present with counsel. The state's present as well with the prosecution. Before we move on with this group of jurors, the first thing I would ask the jurors to do, just so we can confirm with our seating chart, is if each of you would hold up the red card you have and give us a moment to confirm who's here and who's not. All right, thank you. Having reviewed where the jurors are seated now, I'll ask if there's a issue or objection to the manner in which the jury panel has been recalled and seated today. Any objection from the state,
No objection, Your Honor. Thank you.
from the defense?
No objection, Your Honor.
Okay, thanks, counsel. Ladies and gentlemen, thank you for returning this morning. You've been recalled as prospective jurors in the case now before us. I'll reintroduce my court staff again. My name is Stephen W. Boyce, and I'm the District Judge of Fremont County, Idaho. I'm in charge of this courtroom and trial. The clerk assisting today is Shannon Holstein, who's seated to my right, and she keeps minutes of these proceedings and will be administering oaths to you as jurors. The courtroom deputies are here assisting in maintaining the courtroom order and helping the jurors move about where they're supposed to be this morning. Our court reporter is Mary Fox, seated to my left, and she takes a stenographic record of everything that's being said here today. And then my staff attorney is Courtney Stallings, and she assists me with legal research and administrative issues that come up throughout the day. Each of you has been qualified to serve as a juror of this court, and each of you has filled out a questionnaire that's now been reviewed by the court and the attorneys, and it was determined to recall you for further questioning. The first thing we do in a trial is to select 18 jurors consisting of 12 jurors and 6 alternates from among you. I'm going to ask the clerk to now have a roll call of the jury using your red card numbers. So if you would please audibly state you are present or here when your number is called, that will help us keep the record of who has appeared. Madam Clerk, would you please conduct the roll call now?
Juror 1635. Juror 1645. Juror 1658. Juror 1680. Juror 1736. Juror 1760. Juror 1779.
Here.
Juror number 69.
Here.
Juror number 84.
Here.
Juror number 126. Juror number 148.
Here.
Juror number 208. Juror number 229. Juror number 379.
All right, the court will note 2 jurors, 233 and 262 have failed to appear. I'll have the jury commissioner's office instruct them that they're required to report today by 5 o'clock and issue an explanation for their failure to show up. If they do not show up or don't provide good cause for failing to appear, they may be subject to a fine up to $500 or imprisonment up to 5 days in county jail pursuant to Idaho Code 7610 and Idaho Code 2208. So for those of you who have appeared this morning, thank you. To assist you in understanding and participating in the jury selection process, I'll reintroduce you at this time to the parties and their lawyers and summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is represented at this trial by Lindsay Blake, Fremont County, Idaho prosecutor, Rob Wood, the Madison County, Idaho prosecutor, Ingrid Beatty, a specially appointed prosecutor, and Rocky Wixon, deputy prosecutor, Fremont County. The defendant in this case, Chad Daybell, is represented by his attorney, John Pryor.
Good morning, ladies.
This is a criminal case, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that Chad Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all of the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source about the case, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, the court is going to request the clerk place this entire jury panel under oath for the voir dire examination. Ladies and gentlemen of the jury, if you would please stand and raise your right hands now.
Do you and each of you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
I do.
Thank you.
All right, the court observed that all the jurors took the oath and are under oath for this examination. Will the attorney stipulate the jurors have been properly called and impaneled, starting with the state?
Yes, Your Honor, thank you.
Yes, Your Honor. Thank you.
Thank you, counsel. In this part of the jury selection, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law, and in Old French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you're called upon to answer a question, you can raise your hand or reference your red card number. We are making a record of the proceedings, so please make verbal answers to the questions in lieu of, for example, shaking your head or nodding. And also, please try to avoid speaking at the same time as anyone questioning you, so the record remains clear. In addition, the court is live stream broadcasting these proceedings for public access, and also the courtroom's open to the public. You are not being filmed or videoed, however, your verbal responses are being recorded and heard by the public. If you have any answer to a question or area of discussion that you believe would be uncomfortable to discuss publicly or embarrassing for you, please notify us that, and we can discuss those issues in a more private setting outside of the public view. Similarly, if your answer to any question may prejudice any other prospective jurors against any of the parties, please refrain from stating that until the other jurors are not in your presence. Also, many of you have knowledge of this case from pretrial media coverage and publicity. Please do not discuss any specific facts or details of the case in front of other jurors in the pool. We'll discuss that with you individually at a later time this morning. I will now read to you a special instruction in this case as follows. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence solely on the evidence provided in this case. That concludes the special instruction. At this time, I'll instruct the attorneys to avoid repeating questions already asked. You may, however, direct follow-up questions to a juror regarding that juror's response to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges for cause, meaning they would ask that you be excused for some specific reason. In addition, each side has a number of peremptory challenges, which means they can challenge a juror without providing any reason at all for their dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned. It has not. Further, if you are excused as a juror this morning, you may be approached to talk about this case, and you can do that once you're no longer a prospective juror. However, please bear in mind that you should respect the opinions or thoughts of your fellow jurors in discussing this with anyone. And we are in the process of trying to obtain an impartial jury. You are not required to talk to anyone. And if anyone persists in questioning you about the case and you don't want to talk to them, then please report that to the court. At this time, then, I'm going to begin the court's voir dire, after which the attorneys will be given their opportunity for their own inquiries. If you're being asked a question or someone else is, please listen to the question and responses. You may be called upon to answer the same question later. The first question I will give to the entire jury panel is to clarify not the questionnaire you filled out that was lengthy last week. This is just in regards to your juror information form, which has information such as the fact that you reside in Ada County and other personal information. On those juror information forms, then, is there anyone here that thinks their information form is requiring an update or is not still true and accurate? If that's the case, raise your card, and nobody answered to that. The next issue the court will discuss is regarding the time commitment for this case. This is scheduled to be a long trial, approximately 8 to 10 weeks. Would jury service of that time frame create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe you'll suffer a hardship for serving that long, please raise your red card. All right, please keep those held up for a moment. All right, I'll take these up individually then, starting with the end there, juror number 69. If you'll give me a moment, I'll locate your question then. Sure. All right, you did express a concern about employment obligations in your questionnaire. Do you want to provide any further explanation about that?
Yeah, I'm a part of a software development team, and we work on a lot of different projects across our organization. And my absence would potentially cause them a hardship, and I worry under the subtext of it, if I can't get out of jury duty or something for a quarter, that I don't feel like I'll be punished while I'm on the jury, but I just worry about maybe retribution in the future. And I don't know. I would say I'm squarely on the fence if it's a good idea for me. And being the only income earner in my home, if it's a risk worth taking. And I'm just not sure. So you said, is there possibly a concern? And I'm on the fence.
All right, without naming specifically where you work, because I want to preserve your privacy here, I will note that, as I understand it, is a fairly massive corporation with a lot of
That's fair.
employees. Is that fair?
That's fair.
How many employees total at your company, if you know?
I can't speak to it. Thousands, tens of thousands. On my team specifically, there's less than a dozen that can do what I do and have intimate knowledge of the company's processes. There's really very few of us that do it.
Have you discussed with your employer the potential that you may be required to serve in this case and the length of time?
I get a sentiment, fingers crossed, and I assume they hope I get out of it.
Any questions following up on voir dire from the state?
Just a few, Your Honor. Juror 6-9, do you feel like not knowing, would that be in the back of your mind if you were to sit on this jury?
Do I feel like not knowing would
that be weighing on your mind if you sat on this jury, what the potential ramifications could be to your employment?
it is in the back of my mind. Yeah. Again, they are a corporation, and I think they've probably dealt with jurors before. They probably know that they can't sack me because I'm selected for a civic duty. But in the back of my mind, I'm squarely on the fence. I don't know. I trust the people that I work with. I chose to work with them because they have a good community vibe, I guess I'll say. They would potentially pick up a civic duty, if they knew that I had a hardship. If someone's sick, everyone stands up. So on an individual level, I think they're good. I don't know if I'll be punished in corporate America at the end of the day.
So, and I guess my question would be, do you feel like that would be distracting to you if you were to sit on this jury? Do you feel like it would be distracting you from being able to give the case your full attention? Does that make sense?
I do. Unless can I tell them what's going on? Because they may say, pick a vote in my team. They say, you know what? We got this, Dan. Number 69, go for it. But without that, I can't say.
Judge, I think given that information, I guess the state's concern would be, it sounds like this is something that will weigh on this juror's mind while it's an unknown hardship going off the information that we have today. The state would make a motion to allow this juror to be removed for hardship.
All right, let me ask one follow-up question and then I'll hear from the defense. But have you inquired at all as to whether or not you continue to receive income during the time of jury service?
I did review our policy. I do get the majority of the time is written in policy. I have not inquired beyond that. Again, we have a family dynamic in there. They probably work with it.
All right, any questions from the defense?
So there's no assurance that you're going to get paid for the entire 8 to 10 weeks of this trial, is that fair?
I don't have that assurance.
And you indicated one of the first things you said is that you're the sole provider for your family.
That's correct.
And if there's no assurance as to whether or not you're going to get paid, potentially this is going to be a financial hardship.
Correct.
And in addition, personal knowledge of processes involved in your occupation. I'm not going to talk about your specific occupation, but I'm familiar with it. And cases are personal to the person who works on those projects. Would that be fair?
Yes, we have some cross trading, but I lead other projects, yeah.
And the reality is your corporation going to be willing to wait for 2 or 3 months on some of these projects that are personal to you while we decide this case? Do you know the answer to that?
The real fear, I guess, and it's probably understandable, is that they figure it out without me. And then,
They don't need you.
and then they don't need me after the case. Is
Judge,
really where it comes from.
I'm going to also join in the state's motion that move to exclude this juror number 69 for comments.
All right, well, juror number 69, I've really been on the fence on this. I'm listening to your responses. The issue here is I think you have expressed a concern that if you're serving, this is going to become a distraction for you, being concerned about your employment. And for that reason, I am going to allow and grant the state's motion to strike on purposes of hardship. I will say that I find it somewhat disappointing that a corporation this size would not provide a feasible way for its employees to serve in their civic capacity as jurors. And I'm sure your company is involved in litigation all the time and has trials and expects other people to come in and submit their time to help them in a case. And again, I can't imagine that a corporation that big doesn't have a way to accommodate jury service, but I believe you that you feel very concerned about being able to do that. So with all that in mind, you are excused. Thanks to the court for coming in and filling out the questionnaire.
Thank you.
All right, the next juror I'd like to address is juror 148. Yes, sir. I'll note in your questionnaire, you didn't provide any concern of hardship. Can you explain to the court how this may impact you if you were required to serve?
As of now, I just started a new job. I've only been there about 12 days. So I did take a $10 cut out in February.
And when you say $10, you mean $10 an hour?
Yes.
Okay. Is this a full-time job?
Yes.
Is it your sole source of income?
Yes.
Have you discussed with your employer the fact that you could be required to be involved in a long jury service?
I did. And they really have not told me any information about it. Except really started the job.
So they haven't provided you an assurance you would receive income during the time that you were required to serve here?
Yeah.
Okay. Any questions on board from the state?
No, Your Honor, I think given that additional information, the state would make a motion to have this juror removed for cause based on hardship.
Response from the defense?
Judge, I would also join in a motion to have this hardship. It's probably so the income is necessary to survive is what I anticipate. So I'll also.
All right, the court concurs here, given your employment situation, and then without you being able to know how that would impact you in a brand new job, I do agree that would potentially constitute a financial hardship for you, given the length of this trial. So thank you for completing your questionnaire and returning today for further questioning. You can be excused, and please drop your questionnaire off with the bailiff as you leave.
Thank you.
You're welcome. Juror number 208, we'll talk to you next.
Sir?
All right, you did express concerns in your questionnaire regarding your employment, and you could explain, please, what you know about your job situation and how that may be impacted if you are required to serve.
So while I would have security of continued salary during this time and my employer is able to work with me, I am a teacher. So that would put me out through the remainder of the school year during testing season, which is extremely important to my role and my students. I also have additional jobs outside of this, so I don't know what they would require of me for my evening work.
All right, and you're the sole income provider for your family, is that correct?
Yes, that is correct.
Okay, would the state like to inquire on board that?
So you indicated that you would continue to get your salary,
Yes,
is that correct?
yes,
But it sounds like you have concerns about leaving your classroom.
yes.
Do you feel like that would be in the back of your head and a distraction from giving this case your full attention?
I think the burden of preparing for somebody else to be covering my position would be like, it would be a lot.
A lot to juggle in addition to this.
Yes, because it would require me to go in on the weekends and prep things for somebody else to cover my role.
Your Honor, given the statements provided by this juror 208, the state would make a motion to allow this juror to be removed for hardship.
Response from the defense?
Judge, may I have one here?
Yes.
You mentioned that in addition to being a teacher, and it's no secret that we don't, all right, well, I guess in my opinion, we don't support our teachers financially as much as we should. And I know a couple of teachers from the same place you work. And they also work a second and third job to make their bills and meet their financial obligations. And that's what I'm hearing from you as well.
Yes, that is correct.
And having to do that, there's no assurance that you're going to get that extra money to meet your financial obligations.
I suppose that would be based on whether or not sequestering is required during this case, or if I would still be allowed to work those evening jobs.
So in other words, you would have to work an evening job in addition to being able to pay attention to this. And then also take care of our probably most precious resource, which is our children. And you're going to do all of that and do that for 10 weeks. Is that what you was trying to get here?
I don't know what the workload would feel like.
Probably train for a marathon too in the meantime, right?
And I've done that.
Yeah. Okay, Judge, I'm going to move for cause. I think that is way too much of this charge.
All right, I've considered your personal situation here with both employment and family obligations based on a motion of the state without objection from the defense. The court agrees that this would constitute a hardship. Thank you for returning and taking the time to fill out your questionnaire last week as well, and you can be excused with the thanks of the court. All right, juror 379. In your questionnaire, you didn't mention a hardship. Can you explain to the court how this may constitute a hardship if you had to serve as a juror?
Certainly. I originally was under the impression that my employer would be supportive of the jury. They are, but up to an extent, and there'd be over 80% of the time on the jury that would actually be without pay.
Okay, did they give you a number or term of what is covered? Is it 2 weeks or something? So you did confirm your employer covers only 2 weeks, and then you
I was unaware when I filled out the questionnaire and what that time frame was. But only found out afterwards. I'm on a team of 6. So leaving in that team would be a big impact to their ability to cover all the jobs and work that I do.
all right, Fordar from the state.
No, Your Honor, given that additional information, the state would make a motion to have juror 379 removed for cause based on the hardship expressed.
Judge Alston.
Okay, noting that you didn't originally feel you had that hardship, you confirm that now, talking to your employer, the court will sustain the motion of the state concurring by the defense to allow juror 379 to be excused for expression of a hardship. Thank you for coming back and completing your questionnaire as well. You're welcome. All right, I believe that concludes the questioning regarding the hardship on time commitment. For those remaining jurors, thank you very much for your willingness to dedicate your time chosen to serve in this case. The next matter I want to raise with these remaining jurors relates to any knowledge you may have of this case. As I mentioned earlier this morning, please don't state any facts. We'll talk to you separately outside of the presence of other jurors about what you may know. If you do know something about the case, and in addition to what you've been instructed here and last week, and not just, for example, the name of the case or something, but any information or facts that you've obtained through media coverage of the case, if you do know, please raise your red card now and we'll figure out who we'll be talking to about that later. Okay, thank you. I'll next ask you about your the subject matter of the case. As I've mentioned in reading the charges, this case involves allegations of murder, conspiracy, and insurance fraud. And would the subject matter of the case make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case? All right, no one answered yes to that. Next, I'm going to ask you several questions that will seem like they're very obvious, but I'm required to ask those pursuant to Idaho law to make sure there's no connection you would have with any of the parties here or the defendant. Are any of you related by blood or marriage to the defendant, or do you know him from any business or social relationship? All right, no one said yes. Do any of you have any kind of legal relationship with any of the attorneys here, including a relationship such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger? No one answered that. Are any of you a party in any civil action or lawsuit against the defendant, Mr. Daybell? No one answered that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the prosecutors that are here today? No one answered that. Do any of you have now, or have you in the past ever had an attorney-client relationship with any of the attorneys here or with Mr. Pryor or his law firm? No one responded to that. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offenses charged? No one answered that. Do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? No one answered that question. Are any of you unwilling to follow the court's instructions to you as jurors as to the law you must apply in determining this case? No one answered that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another and render a verdict in this case? Nobody answered that. Are there any of you that if you are a juror in this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law instructed by the court. No one answered that. I have one final question then in my voir dire. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? Nobody responded to that question. With that, the court then passes its voir dire to the state. After that, the defense may inquire as well.
Judge, could we have a sidebar, just very briefly, please?
Sure. All right, in conferring with counsel, I'm going to conduct a little bit of additional voir dire. I'll note that, first of all, this morning when the court received its juror affirmations of the jurors, those have been received and submitted. One juror that's still here did potentially have something to discuss on that, so I'll pick that up at this time. So juror number 1645. You said something on circle that maybe access social media or something regarding the case since you filled out the questionnaire. Can you explain that?
Correct. I've just seen things pop up on my feed, so I haven't. I don't care to know the details unless I have to look further into it, but I would say, what I've seen on headlines,
Okay,
essentially, but I haven't.
all right, and we will talk to you individually about that, but so, something came up, but you didn't go off and do your own research while you were away, is that correct?
Right.
Okay. Also, in your questionnaire on hardship, you did talk about possibly having a hardship with the trip coming up and work. When I asked about hardship, you didn't respond. Is that something you're still concerned about, or have you sorted out your ability to serve during this time frame?
As far as the trip goes, it was purely for enjoyment. I haven't bought my plane ticket yet. So it's not confirmed. And I do work with a vulnerable population, but I've reflected and ultimately like it would be okay without me. So.
Okay, well, I appreciate your willingness to continue. One other juror I just wanted to discuss, also potentially, travel plans. Juror number 1658. And those are coming right up like tomorrow, if this is still accurate. Is that still something? Yeah, okay. Can you explain, this trip and whether or not that's going to be a hardship if you are required to miss that?
I mean, I have already bought the flights, but it is his girlfriend's wedding in Texas.
And you did pay for the flights. Let me ask the state if they've got any additional voir dire for this juror on hardship.
The state does not have any additional questions, Your Honor.
Mr. Pryor,
Judge, I'm gonna move for cause to exclude her.
so this morning when I was discussing the hardship, you hadn't raised your hand, but you did check on your questionnaire that it would be. Can you just, I guess, confirm how you're feeling as you sit here now about the potential of missing this?
I guess that I didn't consider it a hardship to miss out on the trip. It would be unfortunate, but I also didn't know timing as far as when I would be required to be here. It would be after the trip.
All right, well, the defense has made a challenge for hardship. How does the state respond?
Your Honor, the state would submit.
All right, juror 1658, I guess, are you standing by what you put in your questionnaire, which was, yes, this would be a hardship, or have you changed your mind and said that being here is not going to be a hardship if you are required to be here and miss the trip?
I guess I'll stand by saying it's a hardship. Things that I'll be in trouble.
And it has been paid for. The court is, and thank you very much for your willingness to serve. I'm going to grant the request of the defense on 1658 and allow for excusal for hardship. Thank you very much for returning today and filling out your questionnaire. All right, we'll next move on then to allow the state voir dire.
Ladies and gentlemen, I appreciate you being back this morning. I know this process has already been somewhat lengthy. You were all here last week and filled out questionnaires, and now we have you back here today. The judge has already touched on this, but I just want to also touch on it. The reason that we're going through this process the way that we are is because we're trying to select a jury that can ultimately be fair and impartial in this case, that can sit in a trial of this matter, hear all the evidence, give it the weight it's due, and ultimately render a verdict. Both the defendant, Chad Daybell, and the state of Idaho deserve a fair trial. And in order to have that fair trial, that's why we go through this process, to make sure that we get jurors that truly feel that they can serve that role. As we go through this, and the judges said it, but if at any point there's something that I ask you that makes you feel uncomfortable and you would like to talk about it outside of a group setting, feel free to say. That is not going to be my intention at all, but sometimes I may not know something that's part of an answer that you feel you don't want to discuss in front of everyone. If that's the case, please just let us know. That's not my intention at all. But I do want to talk to you all a little bit. So one of the first things I want to talk to you about is I'm going to say the term brutal honesty. And if I use that term, juror 1779, what comes to mind?
Being entirely honest and not spinning.
Thank you for that. And juror 1760, how about for you?
Brutally honest. In a way.
Thank you. And would you all agree that it may mean not worrying about hurting someone's feelings, not filtering the information, not holding back? So for me, I have a niece that she's actually older now, but when she was younger, I quickly learned that she could be the person for me that would give me brutal honesty. She hadn't learned the filter yet. If I wanted to know how my hair really looked or what an outfit looked like, and I went to her, she did not hold back. She gave me that brutal honesty. And I don't know, I saw some smiles. Do all of you have someone in your life like that, whether a kid or a trusted adult that you feel you can go to and they're just going to tell it to you straight? I see some nods. So the reason I bring up that term today is for a couple of reasons. One is as we go through this process, I'm going to ask that of all of you. Just tell it to me how it is. Don't feel like you have to hold back. Both the state and the defendant want you to just be completely honest about your feelings on things that we talk about. The second reason is if you're selected to be on the jury, at some point the judge will give you more jury instructions. And at some point he'll let you know that you can start to deliberate with each other. And I want to make sure that you feel that if put in that setting, that you feel that you can just be honest and you can discuss things. Hearing that, does anyone have any concerns right now about ability to sit on this jury and just be brutally honest? I don't see anyone saying yes. Thank you for that. The judges talked to you about the charges in this case. We have multiple counts of conspiracy to commit first-degree murder, and we have multiple counts of first-degree murder. This case, this trial will include, or most likely include, evidence that may include photos of a graphic nature. We have 2 children that are victims in this case and a mother of 5. Does anyone have concerns that if you were to see graphic photos that may be unpleasant or other evidence like that, is that going to cause anyone serious concern about their ability to sit on the jury? Juror 1645. Can you talk to me a little bit about that?
Yeah, sure. I wanted to verify, I did write on my questionnaire, but in terms of looking at the physical accident, what that is, but would be probably necessary in some cases.
And if the court were to want you to review all the evidence so that you could give it the weight that it's due, do you feel that that would cause you some concern about your ability to do that?
It just causes me concern. I don't believe my ability waivers, but it causes me concern.
And it's totally normal to have some concern or to be worried that you may have a reaction to those type of photos. Does anything about your concerns make you think that you would have a problem viewing that evidence and giving it the weight you think it's due and in relation to any and all other evidence presented?
Yeah.
Thank you. And I appreciate that. And when I talk about brutal honesty, that's exactly what I'm talking about. I want to know what your thoughts are on these things, concerns you may have. Juror 1680, I think you have a kid, and I won't get into specific details, but having a child, does that cause you any concerns with possibly seeing photos that may depict children that may be unpleasant or graphic in nature? You feel that you could look at those and just give them the weight they're due?
Yes.
Thank you. I appreciate that. Has everyone here been on a plane before? I see everyone nodding. So you get on the plane and at some point someone comes over the PA, whether the pilot or the stewardess, and tells you, sit back and enjoy your flight. We're going to arrive at our destination at such and such time. If instead of that announcement, the pilot came on the intercom or the PA and said, well, I think we're going to arrive at this time and I'm going to try to land the plane. Do my best. Would anyone have concerns getting on that plane? Yes. And you're 84, I think I saw you nod your head. You have concerns?
Yes.
Would you get on that plane?
I mean, the time and destination, generally I make ample time in case of delays and such when I travel. But if the pilot wasn't confident in his ability to do his job, he probably shouldn't be a pilot.
Would it make you not want to fly on that plane?
Yes.
Thank you. And juror, let's jump over to juror 229. How about you?
Like you can't wait. Dropped into lake.
Would you be okay with the pilot saying he wasn't sure if he could land the plane? You'd want him to land that plane.
Land someday.
Thank you. The reason I talked to you about that is because in this case, and I've said it before, but we want to ensure that jurors feel that they can be fair and impartial in this case, that they're open to hearing the evidence, weighing that evidence, and rendering a verdict. And so kind of like landing the plane, we just want to ensure that any juror feels, yes, I can do this. Anyone have concerns hearing that? Thank you. So I have a little boy, and in the mornings when he gets up, 9 times out of 10, if I ask him what he wants for breakfast, it's cheesy eggs. And there's a specific way he likes me to make them, specific ingredients. He wants his eggs, the milk, the cheese, and the salt and pepper. Sometimes I might add extra cheese. Sometimes I might modify it a little bit, but for the most part, that's how he likes his eggs. Does anyone else have any experience with something like that? And juror 1635, I see you nodding your head. What's your experience?
I have a 3-year-old daughter and she wants her food, toys.
And do you oftentimes follow what she wants? Do you sometimes modify it?
Maybe sometimes.
And juror 126, I saw you nod your head as well.
My dad's cheesy eggs are the best, so I understand where son's coming from.
And is there a special way he makes them?
He puts cheese in there and a certain way he scrambles them with perfect textures, peppers, everything.
And when he makes you cheesy eggs, is that how you like him to make them?
Yes, I like eggs any other way.
Thank you, I appreciate that. And the reason I bring that up is because similar to a recipe, at some point, the judge is going to give you jury instructions. And sometimes in our everyday life, we may take a recipe and we may modify it. We may make it better, we may take something out that we don't like. But when the judge gives you the instructions, you're not going to be able to modify those. Even if you look at them and think, why does the state have to prove this element? Or why don't they have to prove this element? That's not going to be up to you to decide. Does anyone have any concerns with their ability to take the instructions as given by the court and simply follow those as they're written? Doesn't look like anyone has concerns with that. And some of the instructions the judge will give you are going to deal with the elements of certain offenses. So kind of like a recipe, the certain ingredients that you have to use, they're going to have certain elements the state has to prove. And when it comes to homicide, an element is going to be that the defendant engaged in conduct which caused the death of a person. So basically, an element that they did it or that they were involved in it. But one of the elements is not going to be that the state actually has to prove the cause of death. So an element's not going to be the cause. So we have to prove they did it, but not necessarily how. Knowing that that might not be an element, does anyone have concerns about their ability to follow the court's instruction as given?
I have a question.
Yes.
And is it possible to prove that somebody did something without knowing the details of how?
And for the record, that was juror 1645. And I do that just, we have a court reporter taking down the numbers. So the court would give you specific instructions, and in them, he'll tell you exactly what the state has to prove. So do you think that if the court gave you those instructions and said, here are the elements, would you be wanting the state to prove something else?
Right. No, I can follow them.
You'd be able to follow the instructions, even if, and I didn't want to get too much into the instructions because the court's going to give you those. That's why I'm not trying to completely sidestep. I just don't want to get too far into that. But do you think if the court gave you that recipe, those instructions with the specific elements, and you felt that the state had met their burden, because the burden will be on the state to meet that, if you felt the state met their burden of those specific elements, would you be able to follow that instruction? Thank you. Does anyone here follow the NFL? I see one hand. So juror 1635. You don't have to weigh in on how you felt about it, but Kansas City Chiefs won the Super Bowl this year. In your opinion, should everyone on that team get a ring?
Yeah.
So when the team wins the Super Bowl, they all get a ring. Even the second string that maybe didn't play, coaches. And do you think that's fair for everyone to get the ring? I appreciate that. And juror 1779, do you think everyone on the team should get a ring?
Yeah, I don't follow football very closely, but yeah, they're all a part of the team. Team should get.
Because they were all part of it.
They all help.
Thank you. And I bring that up because the judge has already touched on a jury instruction, or he's already given you a jury instruction today that touches on conspiracy. And he talked to you about a conspiracy being an agreement by two or more persons to commit a crime. He also talked about that you would not be to consider Lori Vallow or Alex Cox's guilt or innocence, or what may or may not have gone on in any cases they may or may not have. However, you will hear evidence of actions that are alleged to have been taken by Lori Vallow, Daybell, and by Alex Cox. So you're going to hear about that in the trial. And remember, a conspiracy, the judge has already started to instruct you on that, an agreement between two or more persons to commit a crime. An additional element will be that one of those persons, and just one, has to take an overt act, or they have to do something that would further that conspiracy. So something to move forward towards that crime. Do any of you have concerns if given that jury instruction that there's the agreement, they intend to do it, and only one has to commit an act? If you have person A, B, and C, and only person C doesn't act, are you okay still holding person A and B accountable pursuant to the instruction given? Anyone have concerns with that? Thank you. So today, when you were headed into court, if the sky had started to turn gray, and then you came into the courtroom and we shut all the windows, you couldn't see anything, we pulled blinds down, and you go outside and there's rain all over your car, and the grass is wet, and the pavement's wet, and you start driving home, the roads are wet, and you see a rainbow, would you be able to determine what had happened while you were here in the courtroom? And juror 1736, I see you nodding your head. What would you determine had happened? Let it rain. And juror 229, how about you? Would you be able to determine?
Yeah, let it rain.
And you'd be able to make that determination without ever seeing it actually rain. So in this trial, you may hear different types of evidence, and you may hear the term, or you may be familiar with the term circumstantial evidence. Can you all commit that you would listen to any evidence as permitted by the court, give it the weight it's due, and weigh it in relation to all other evidence? Knowing the charges, and I saw a lot of nods there, knowing the charges include homicide, has anyone come in today with a preconceived notion of a specific type of evidence that you think the state would have to show you? Are you all open to hearing the evidence as presented? Thank you so much for your time. I really appreciate it.
All right, thank you, Ms. Blake. Mr. Pryor, if you'd like to commence with voir dire for the defense.
Good morning, ladies and gentlemen. My name is John Pryor. I'm here today because Chad has let the court know that he's not guilty of these charges. And what that means is that we have a trial. And part of a trial is that we have to present facts. Facts and evidence. That's what a trial is about. Is there anybody who doesn't understand what facts and evidence are? Okay. And before I go any further, I want to talk to you a little bit about this process. And the reason we do this is because it gives us an opportunity to get an idea about your feelings, about how you feel about a number of subjects. Ms. Blake talked about cheesy eggs and about planes and about raining and football, I guess, and to get an idea of your views and thoughts. And what's more important than anything else is that no one is wrong about their feelings or opinions. We all have different feelings. We all have different opinions. We all have different life experiences. Everybody agree with that? For instance, I want to make sure I get the number right, so I apologize for looking down, but juror number 84, he went to school in a very unique place.
Yes.
And I went to school south of there, in the southern end of that place. But what we do know about that is that the people up there have pretty strong views about a lot of things.
That's true.
And the other thing we know about that place in northern Michigan, right?
Correct.
And we have an expression for those of us who at least were educated in that state, myself and you. What do we call the people up in northern Michigan?
Ubers.
Ubers, right. And Ubers have a different idea about a lot of things, right?
That's correct.
Strongly religious people.
Generally.
Yes. They are very strong about their gun rights.
Yes.
They love the outdoors.
That's correct.
And they have got to, under all circumstances, those Ubers have got to love snow.
Yes.
Because there's a lot of snow up there.
It would be very difficult if you didn't.
Right, because the snow comes in sometimes in October, and we're still skiing up there in April and May.
That's correct.
But the idea is that they come from a different background and experiences. We all have different backgrounds and experiences. You understand that, right?
Yes.
And it's hard. I spent a lot of time up there in my summers. Okay? And I agreed with some of the things those folks did for. I disagreed with some of the things, but we all have different perspectives, right?
Correct.
And all of us have different perspectives as well. Does anybody not agree with that? Thank you. So I want to ask a couple of general questions, and these are things that I need to ask just so we're sure and we're all sort of talking about the same thing. So I'm going to go down this list, and it may be a little tedious at first, but it is kind of important just to get an idea, okay? So please bear with me a little bit, if you folks could, please. So when you folks heard the charges, and the judge read the charges, and it talked about murder, did anybody make a decision at that point that Chad is guilty of the murder? Anyone? Okay, I don't see any yeses. Okay. Does anybody believe that Chad needs to testify to prove that he's innocent? Does everybody understand that any defendant in any criminal case does not need to take the stand, and you should not hold it against him? Is anybody going to hold it against Chad if he decides he just doesn't want to talk about this? Okay, no one? Also, he doesn't need to present any facts or evidence. Does everybody understand that? Facts and evidence. He doesn't need to present any, and does everybody understand that you can't hold that against him? Everybody understands, and I'm getting a little older and talking about civic classes and history classes. I don't know what they teach anymore in school. I have no idea. But one of the things we learned in American government is that we're a very unique country, a wonderful country. And in this wonderful country, these prosecutors have the obligation, and they must present evidence to prove that Chad is guilty in this case. Does everybody understand that? And that we can't prejudge him. We can't put blame on him for anything until you've heard all of the evidence. Can everybody commit to me that you will not make a decision in this case until you've heard all of the evidence? I want to talk a little bit about recipes. Ms. Blake talked about cheesy eggs. I don't like cheesy eggs, okay? I'm sorry. That's not my thing, okay? With all respect to the Ubers and our friends in Wisconsin over there who put cheese on everything. And I mean everything up there.
That's correct.
Yeah. Ms. Blake sort of drew an analogy between the charges and putting together a recipe. And she said, well, if the state, puts all the ingredients of the recipe together, are you gonna commit to proving him and judging him as being guilty? Well, I guess I want to ask you something, a little differently. If the state doesn't mark off all the boxes in the recipe, they're claiming this is how this works. If they don't hit all the marks on the recipe, and they aren't able to prove one or two or three of the, it only needs one, right? We only need to mark off one item on the recipe. Does everybody agree that the verdict is going to be not guilty? Is there anybody who believes that it should be guilty? Raise your hand if you think it should be guilty. If the state doesn't notch off all of their marks on the recipe. No one. So when Ms. Blake talks about a recipe and she's putting together her cheesy eggs in the next 10 weeks, she needs to take care of all of the items on the recipe, right? But the reality is that we're not talking about a recipe here. Because folks, this is a homicide. What Chad's being accused of. And really what it comes down to are facts. Facts and evidence, okay? Facts and evidence. And I'm going to bring that up again sometime in the future if you were on the jury. I'm going to talk to you about facts and evidence. I want to talk to you a little bit about what the judge said. And the judge gave an instruction. He said it's a special instruction. And that special instruction is that there has to be an agreement. There has to be an agreement. And then once there's an agreement, and you folks decide there's an agreement, then you consider the evidence against Mr. Daybell, against Chad. Does anybody understand, or let me put it a different way, does anybody misunderstand what an agreement is, or doesn't know what an agreement is? Can you raise your hands if you know what an agreement is? Okay. Okay, I think what I'm going to do is go to juror number 1680. Talk to me a little bit about what an agreement is.
An agreement is when both parties come to the same conclusion.
Does anybody agree with that or disagree with that? Does there need to be more or less? Or is it just come to the, can it be just a discussion about a topic? Juror number 1779. And I got some feedback on this from, I made this comment yesterday. I talked about my beautiful girlfriend, who I cherish deeply. And we talk about a future. And I say, we talk about, well, where are we going to be in 10 years? What are we going to be doing? And she talks about cooking and all of the things that we do together and our common interests. If I entered into an agreement to marry her,
Based on what you said, no.
anybody believe that I entered into an agreement to marry her? All knows. I don't want to tell you what she thought I meant by that yesterday. And it may be a little different, and I think she's taking some liberties with what an agreement is. But when you hear the words speculation, does everybody know what the word speculation is? Everybody? What about hunch? You know what hunch is? There's another big word, and I don't use it very often, but I had to Google what speculation, and all of these words came up, and I wouldn't use this other one very much, but conjecture. Does everybody understand what conjecture is? No? Yes? Okay. So when you're looking at facts and evidence, and you're trying to make a determination of what happened and what occurred in the case, do you think under any circumstances you should speculate about the facts or guess? I see at the very back there, and juror number 229, you're shaking your head. Should you speculate when you're trying to figure out what happened in a situation?
No, you should just use the evidence.
Okay. And in a serious situation where you're involved in something serious, Ms. Blake got into a little bit of detail, but this is a homicide case. Should we guess or speculate about any of the facts in a homicide case? Juror number 126, you shook your head too. Is that an area that we should be speculating in? Conjecturing? Hunching? Guessing? Looking at it and saying, well, you know, this is what I think, right? Is that something that we should even be doing? Does anybody disagree with that? Thank you, folks. I appreciate it. I'm going to go over one last subject, and Ms. Blake talked about that a little bit. I won't spend a lot of time on this. Being involved in this case, we're provided a certain amount of evidence. And some of the evidence in this case deals with very graphic pictures. Very graphic, extremely disturbing pictures. And I've talked to some of the other groups about this. These graphic and disturbing pictures will hurt your heart. Does everybody understand what I mean by hurting your heart? And they will hurt your heart. They hurt my heart. I look at these pictures and it hurts my heart. But the reason for graphic pictures or sensationalizing something is to get a reaction from people. Would everybody agree with that? But the purpose of showing people these things is to try to gain some kind of reaction. Is there anybody who disagrees with that? You disagree with that? Okay, you disagree with that? Okay, I'll get you. Go ahead, juror number 1645.
I believe the reason for showing the pictures is.
Right.
For evidence, not pictures.
Okay, I appreciate that. And then juror 1779.
Same.
To show evidence.
Yeah, if it's showing evidence.
Right.
It's evidence.
Right, but if it causes a reaction, and the reaction is that you're immediately going to put the blame or cause on Mr. Daybell, Chad, is that fair?
The reaction doesn't necessarily mean that the blame is there.
Okay,
The reaction is reacting to the situation
right.
and the evidence presented. But again, to your point earlier on the recipe, you gotta tick all of the boxes. Just because there's evidence there of one thing doesn't mean that there's a relationship there to all the rest.
Does anybody disagree with what juror 1779 said? And I don't either. And I appreciate that because you just saved me a lot of time. You just talked about something that's exactly right. And then when you see pictures, it doesn't mean that from the pictures you go to guilt. What it means is you look at the pictures and it's one piece of evidence and that you need to say, okay, let's see what everything else says before we jump to any conclusion based on these horrendously difficult pictures that hurt our hearts. Would everybody agree with that? Everyone? Thank you. Ladies and gentlemen, I want to thank you for letting me spend some time with you. Your opinions about things are very important to all of us. And it's important that we get an opportunity to listen to how you feel about certain things. And I want to thank you for letting me delve into your lives in this way and do this. And Judge, at this point, I'm done. Thank you.
All right, thank you, Mr. Pryor. We are going to next move on to some individual voir dire with each of you. And I think I'll suggest we go through a few of these and then take a mid-morning break sometime around 10:30 or 10:45. Is that schedule okay with council?
Yes, Your Honor.
Yes, Your Honor. Thank you.
All right, thank you. We're gonna start with the front row, 1635. So ma'am, if you'll just remain where you are, we're gonna have your fellow jurors retire to the jury room with this time.
All right, please.
All right, thank you. Please be seated. All right, for juror 1635, there's a few things we'll talk to you about this afternoon. We'll start with the information you do have about the case. You have some, and you acknowledge that in your questionnaire as well as in your response to that question this morning. When I asked if you had formed any opinion about the case, you said no. But the way I asked it was in pretty ultimate terms of, an unqualified opinion. In this instance, I'm going to allow the state and the defense to inquire a little further to see how much you know about the case or the facts of the case and whether or not that may lead to you already have thoughts about this defendant that would be improper. So again, these are not questions indicating you've done anything wrong whatsoever. You have the knowledge you have coming here, and we want you to be perfectly honest with you, and you can discuss these details openly here without the other jurors. So with that in mind, I'll start with the state to see if the state has any additional voir dire relating to bias here.
We do, Your Honor.
Go ahead.
Judge, if I may, I actually have one question unrelated to bias, but I think we should probably begin with that.
Okay.
Ma'am, in your questionnaire, if I recall correctly, you indicated that you're no longer a resident of Ada County,
Yes, I moved in mid-December.
and you were summoned to this trial even though after you became a resident of Ada County.
After you became a resident.
Of Canyon County. Your Honor, with that, I'm not sure, I guess, I don't know if it's a cause strike or not. I'm not sure if she's eligible to be a juror in this county.
Yeah, I think it would constitute an unqualified juror because you live in the wrong county now.
Yeah.
Or the right county, depending on how you like your new place. But I'll just clarify, so you are now a resident of Canyon County?
Yeah, as of mid-December.
All right. I think the juror needs to be excused based on that. We have to have Ada County jurors for this particular trial. Any further comment?
No comments.
Okay, thank you so much for taking your time to fill out the questionnaire and returning today. You're welcome. And thanks for catching that, counsel, as well. So we'll have 1645 return, please. All right, this is jurors 1645 and has not indicated an issue with either hardship. On bias, I don't know if there's anything to follow up. We've got additional questions I'm sure we'll go through, but from the state, is there going to be any voir dire requested on any bias here? Unrelated to the death penalty questions.
Your Honor, just briefly. Good morning, ma'am. On your questionnaire, you had indicated, I believe, that you thought that there should be a higher burden of proof than beyond a reasonable doubt. Do you want to talk about that a little bit?
Yeah, sure. it's, the weight of this is huge, and the only reason about, if there was more than that, I believe it should be all of it, so I think the wording was a little bit confusing, and I believe there should be all the evidence in order to have it concluded.
Now, if you were to be instructed by the judge that beyond a reasonable doubt is not beyond a possible doubt or beyond an imaginary doubt, but it's a doubt based on reason and common sense, and there's a full jury instruction on that, so I want to be very careful not to misstate it. But would you be able to follow the judge's instruction on reasonable doubt, even if you held a personal belief that it should be a higher standard of proof? Would you struggle with that?
No, I think I could do that. I think, again, it seemed like, okay, beyond reasonable doubt, there's more there that could be said, and so that's the way I read it, but, yeah, to this point, what I would do was to.
Nothing further at this time.
All right. Okay, so juror number 1645, there's another topic we want to discuss with you. In your questionnaire, I'm sure you recall answering the questions about your attitudes regarding the death penalty. All right. You did give responses here. Are the responses in your questionnaire still the way you feel about that today? I am going to advise you that in this case, it may be necessary for you to make a determination in regards to the imposition of the death penalty or some other penalty. And remember, when you're considering that, it has to be considered as if it would be done in absolute and carried out in the case. So with that in mind, in terms of those questions on the death penalty, starting with your answer, do you support or oppose it? You stated you oppose it. Is that correct? You also had a series of choices about the death penalty of what most accurately represents the way you feel. And you selected a choice that says, I am strongly opposed to the death penalty and will have a difficult time voting to impose it regardless of the facts, law, and instructions in the case. Is that the way you still feel about it?
Yes.
When you say a difficult time, does that mean to you that it would be impossible for you to ever vote for it?
I will not vote for it.
All right, under any circumstances, would you vote for it, even if you were instructed by this court that that is the law and you are required to follow the law as a juror?
Well, I would vote on it, just I would oppose it.
So you would automatically have a no vote regardless of what evidence the state provided?
On the death penalty, yes.
Okay, and if there was an instruction stating that you were supposed to consider it because that's the law, are you stating still unequivocally you will not follow that instruction and would just vote against it in every case, including this case?
I will consider it,
You will consider it?
but I do not agree with it, and so, yeah, that's my answer.
Okay, I would like to allow the state some additional voir dire on this topic at this time, and then I'll allow the defense as well. I may come back to this juror for further voir dire also.
Thank you, Your Honor. And thank you, ma'am, for your honesty about your thoughts on the death penalty. Is it fair to say that you have a deep moral conviction against the death penalty? Would it be emotionally difficult for you to impose the death penalty?
Yes.
Under any circumstances, would you ever agree to impose the death penalty?
Agree to.
Impose the death penalty, give someone the death penalty. So is there any scenario after any amount of evidence that you would hear in this case where you would vote to take someone's life via the death penalty? Your Honor, I would move to excuse this juror.
No.
Any voir dire response, Mr. Pryor?
Yes. Ma'am, thank you. And then again, there's no right or wrong answer here. Obviously, I talked about that. Everybody has an opinion about different subjects. But I want to give you a little scenario. You know, we're all very patriotic citizens in this country. You agree with that, right?
Yeah.
For the most part? No? Okay. You think there are a lot of people out there that aren't supporters of this country, or large subpopulation?
Yes.
And I guess if someone was doing something like a country trying to take over our country, and they started taking prisoners and started executing people in mass numbers, and the government decided that we have to consider the death penalty in that situation. And I'm talking about the most extreme, the most atrocious behavior that someone could behave. Is in that situation, would you still say, I'm not going to vote for the death penalty?
Correct.
Judge, I have nothing else.
All right, I do have a few additional questions then. There were a couple of times you said you would consider it. And what I need to know is, well, I have a couple of questions, I guess. In this case, if you were first looking at determining guilt or innocence, if you knew that determining guilt might lead you to have to make this decision, do you think that could affect your ability of rendering a verdict?
I guess if I ask for clarification.
Yes.
Those separate, like determining guilt versus non-guilt, and then determining death penalty versus non.
That's correct. So think of it as two phases of a trial, determining guilt or innocence, and then considering the penalty.
And can you restate that question?
If you know that considering the penalty is going to come up, if there's a guilty verdict, do you think that might start weighing on you to lean more towards a not guilty verdict because of your thoughts on that?
Right, I already lean that way.
Okay. If you were still a juror in this case and a guilty verdict was returned that you agreed with, are you stating unequivocally and without any doubt here that you would not, regardless of the court's instructions or the facts, impose the death penalty?
Correct.
All right. I appreciate your responses here, and there's absolutely nothing wrong with the opinion you hold, and the court is going to sustain the challenge from the state for this particular juror. These are very rare cases, and thank you for your honest opinions here. You'll be removed for cause for finding that this juror likely would not be able to follow the instructions that the state is entitled to. So thanks for taking the time to fill out your questionnaire and coming back today, and you're excused with the thanks of the court.
Thank you.
You're welcome. So next, talk to juror number 1680. Counsel, is there going to be any voir dire on hardship or bias requested on this juror?
Your Honor, I did notice, I won't say the age of the juror's child. I just want to ask one very brief question.
Oh. Very well. Welcome back, juror number 1680. This is time for individual voir dire. The court will go through some questions with you in a moment, and first I'll ask the state if they have any voir dire on either hardship or bias.
Thank you. Juror 1680, thank you for being here. Just a reminder, there's no right or wrong answers. We just want to clarify you. You didn't mark that you have a hardship. And I just wanted to double check. I won't say the age of your child, but you do have one young child. Do you have any concerns about childcare if you were to be chosen to serve on this jury?
No, I do not.
Your Honor, I have no other questions about hardship or bias.
I will pass. I will pass as well.
Very well. So juror 1680, there's another topic of discussion at this time on voir dire. You filled out your questionnaire, which included a section called attitudes regarding the death penalty. Do you remember answering those questions?
Yes, I do.
And as you sit here today, do you still feel the same way as you did when you answered the questionnaire?
Yes, I do.
All right, I do want to advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. Remember, any penalty you consider should be done as if it is absolute and will be carried out in this case. Do you understand that?
Yes.
All right. In your questionnaire, when you were given a choice of whether or not you support or oppose the death penalty, you selected that you support it. Is that correct?
Yes.
All right. On the next page of the questionnaire, we gave you a range of options to choose from and select what would most accurately represent the way you feel. And you selected a choice that reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still your sentiment on the death penalty and the way you feel about it today?
Yes.
Okay, so you would be willing to follow instructions if the court provided you those in this case relating to the death penalty?
Yes.
Would you be in favor of the death penalty in every case where a murder's been committed?
No.
Okay, finally then, is there anything about your views on the death penalty that you think would prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions on the death penalty?
No.
All right, thank you for your responses. Does the state have any voir dire on that topic?
No, Your Honor.
No, Judge.
All right, that concludes our questions for you then, juror 1680. I'll go ahead and have you return to the jury room with the bailiff and there'll be further instructions once we talk to the other jurors.
Thank you.
You're welcome. I'll suggest let's do one more council and then we'll take a break if that's fine. 1736 will be next. All right, juror number 1736, thank you for returning for individual voir dire this morning. There is some indication in this juror's questionnaire that she's got knowledge of the case. If the state or defense has any questions regarding any bias, we can leave them there. Does the state have questions?
No, I'll be handling this witness in the courtroom. Just indulge me for one moment.
Yes.
So perhaps we'll just start with that question. As you sit there today, can you just perhaps give us a nutshell version of what information you believe you already have about this case?
Just what I've seen on the news, just, I mainly remember the billboards when the kids went missing.
So just billboards?
Yeah, I don't have cable, so I don't watch the news nightly.
Do you recall the names of the alleged victims in the case?
Only two.
And do you recall where the crimes were alleged to have occurred?
No.
Based on what you did see, did you form any opinions or impressions about the case?
No.
Prior to being called as a juror in this case and coming into court, had you heard or recalled Chad Daybell's name?
Yes.
What did you recall or understand about his name before you came to jury duty?
And he was being charged for murder.
Okay, as simple as that, just that he
Yeah.
was charged. You're not aware of any of the surrounding allegations?
No.
Do you feel like there's anything in your prior information that you had that would cause you to be less than impartial as a juror in hearing all the evidence coming in and then deciding whether or not he's guilty or not guilty?
No, I really don't know the case.
Judge, at this time, would I be allowed just to ask one hardship question, potential question?
Yes.
Thank you. Ma'am, I noticed in your questionnaire that I believe you checked that you don't believe that this case would present a hardship if you were selected as a juror.
Correct.
But then you did make some notation that as a mother of children, 3 children, it would help knowing the schedule to arrange their schedule and whatnot. As you sit there, when you made that statement, are there any concerns that you would have that if you're selected as a juror for up to 10 weeks with some sequestration that could happen? Any concerns about being a mother and parenting these children if you are selected as a juror?
Well, I think there's always going to be concerns because they're kids and things can come up. I do have one that's going to start spring football. So I do get concerned like if he gets hurt, something can come up, but they're older, so they don't need a lot of my full attention. I do have a lot of support. I have family here, I have friends here that can help with rides if that needs to be. There's arrangements, so I wouldn't really consider that big hardship, but I mean, there's always going to be concerns.
Fair enough. So would it be safe, you're just really providing that as information to the court, but you don't feel like your parenting is going to impose any kind of a hardship?
No.
If you're a juror.
I've always worked. I've never been a stay-at-home mom. I've always made arrangements if needed to.
Thank you, ma'am. No, I don't have any more questions on these issues.
Mr. Pryor, on either of those topics.
And ma'am, there was a little bit of discussion about some media disclosure, and you said you really don't have a lot of information.
No, I don't have any details.
Right, and one of the things you mentioned specifically is actually you mentioned Idaho Channel 6. And that's where you got some news, but is it your position that the person who reported on this case was very, very fair and balanced and didn't really lean one way or the other?
I actually don't remember reading any articles. I only put that one because that's the only one I follow.
Right.
But
So-
I don't remember reading any full articles or
Okay.
any type of details in the case.
So despite the Channel 6 being the only station that you follow in the Treasure Valley,
Mhm.
you felt that they didn't inflame or sensationalize or do anything like that. They were very fair about it and just reported the facts.
Correct.
Would that be fair?
I think so, yeah. Just
Okay, Judge, I don't have anything else. Thank you.
May we approach on this?
Go ahead.
Sidebar.
All right, at this time, we are going to take a mid-morning break and we will return for some further for dire with this particular juror once the break is concluded. So probably about 20 minutes to come back on the record.
All right, please.
Just go ahead on in, 400 open.
All right, thanks, everyone. We are back on the record. I'll confirm as the broadcast. Thank you. We are conducting individual voir dire of juror 1636. Does the state have any additional questions related to hardship or bias at this time?
No, Your Honor, but the juror number of this is 1736.
Thank you for the clarification. 1736. Okay. Juror number 1736, then this next topic I'll discuss with you and I'll allow counsel as well, is relating to responses you gave in your questionnaire on your attitudes regarding the death penalty. If you have a copy of your questionnaire, I'm referring to pages 12 and 13. Do you recall filling out those questions and thinking about your responses for the attitudes on the death penalty?
Yes.
Okay, since the time you filled this questionnaire out, has anything changed on your opinions, and do you still hold the same answers here? That was a bad question. That was 2 questions. So have you changed your mind on any of these responses?
No.
I am going to advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And remember, any penalty you consider should be done as if it's absolute and will be carried out in the case. So with that in mind, there was a question that said, do you support or oppose the death penalty on page 12? And you did have a good explanation above about that, but you didn't check either box. And did you pass over that intentionally because you didn't think either box applied?
Correct.
Okay. And I'll just read that your thoughts on that on page 12 was, quote, I do not have a strong opinion either to support or oppose the death penalty. And then some other commentary. If you would look at page 13, there were 7 choices for you to choose from on what most accurately represents the way you feel about the death penalty. You selected D, which reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in this case. Is that still the way you feel about the death penalty today?
Yes.
All right. Would you be in favor of the death penalty in every case where a murder's been committed?
No.
Is there anything about your attitude or opinion on the death penalty that would impair your ability to serve as a juror in this case, follow the court's instructions? All right, that concludes the court's voir dire of this juror on that. Does the state have any voir dire?
No, I don't believe I have any questions on this.
Thank you, Mr. Pryor.
No questions for the defense. Thank you, man.
All right, so juror 1736, I'll have you return to the jury room. Thank you for answering our questions, and we'll give you further instructions when we talk to the other jurors. Next up will be juror 1760. All right, thank you for returning for individual voir dire juror 1760. We do have some questions for you, and as we get started, I'll note in just observing, and since the other jurors aren't here, I wanted to ask how you're, just in general terms, how you're kind of feeling about all this today. It seemed like you were maybe somewhat stressed out about the situation this morning. Could you just tell me what your thoughts are at this point in terms of considering whether or not you could serve as a juror in the case?
I have panic attacks with public speaking, so that's kind of really why I'm super nervous today.
Would you like to address this outside of the public presence?
Oh, that's okay, just wanted to say that.
Okay.
And I maybe felt like when I signed that sheet today, I mean, I have seen news on the whole story. Obviously, I have. I've watched it Dateline.
Okay, and we will talk to you about that and what you know. I just wanted to make sure you were doing okay to proceed with where we are right now. Okay, and that's fine. So there is some knowledge of the case this juror has. I'd like to have voir dire in terms of potential bias or hardship with the state. Who's going to conduct the voir dire?
That would be me, Your Honor.
Go ahead, Ms. Beatty.
Good morning, ma'am. If you need to take a break at any time, just let me know and we can do that. So it does look like you had some media exposure in this case. There's nothing wrong with that. We've all had media exposure to some degree, probably. So would you mind just kind of telling me what you do know about the case?
Well, the two people dead. And they found the bodies in Mr. Daybell's backyard.
Now, did you happen to come across any other court hearings related to this case overall?
No.
Okay. Did you happen to watch any other witnesses testifying or anything of that nature in any other proceedings related to this case?
No.
Okay. Did you happen to watch any documentaries other than Dateline?
48 hours. It was 48 hours.
Okay. Have you formed an opinion about Mr. Daybell's guilt based on what you've seen in the news?
I have.
You have. What is that opinion?
Guilty.
Do you believe that you could set that aside and put it out of your mind while you're deliberating?
I want to think I can. It would be tough.
Yes. I really appreciate your honesty, ma'am. Thank you very much. Your Honor, I would move to excuse this juror for cause.
All right, thank you very much for your responses and coming back today. You can return your questionnaire and the court will sustain the motion. Thank you. Next up will be juror 1779. All right, juror number 1779, thank you for returning for some more individual voir questioning. We do want to discuss with you any knowledge you have of this case. Where the other jurors are not present, please provide specific facts to what you do know so we can determine whether or not there may be some bias or implied bias from that. And I'll let the state first inquire on the topic and then allow the defense voir on that issue as well. We'll be doing that.
I will, Your Honor.
Go ahead, Mr. Wood.
Thank you. Juror 1779, thanks for coming back with this. And just a reminder, there's no right or wrong answers. Just tell us how you see things. We appreciate that. It does look from your questionnaire like you have seen some media in regards to this case.
Yes.
It says, from what I understand, and you correct me if I'm wrong, please, that you've seen the local news,
Yep.
but you haven't researched the case yourself.
No.
Can you just, in a nutshell, kind of tell us what you do know about the case?
In general, I'm aware that there was murders and that there was deaths, I should say. I don't know anything from facts because I don't believe the media is stating facts. I believe the media is opinions. And so they're giving their opinions based on raw knowledge that they are given from rumors and conjecture that they come up with. I don't believe that any of it is fact.
Okay.
So while I've seen the media up until probably 18 months ago, when kind of things went quiet, I have made no opinions whatsoever on the case, either way.
Okay. And you agree with us that this defendant has an absolute right to be considered innocent until proven otherwise, correct?
Absolutely.
And do you have any concern that any of the headlines that you have seen, or I'm sorry, the media you have seen would shape your opinion in this case?
No.
And you can commit to putting everything out of your mind you may have heard and rendering an impartial verdict in this case based solely on the evidence in this court.
As I said, I've not seen any facts.
Okay. There's one other thing I want to talk to you about briefly. It sounds like you don't have an opinion, but maybe your spouse does. Is that fair? Based on
That is fair.
your questionnaire.
That is fair.
And if chosen as a juror, are you aware that you won't be able to talk to your spouse at all about what's happening?
I'm sorry.
Yeah. Are you aware that if you're chosen as a juror, you won't be able to talk to your spouse or anybody else about what's going on in the courtroom?
Yes. Yes. Already started.
Okay, so you've already cut that communication down?
Yes,
Is that gonna be a problem for your spouse?
no,
Okay, so she's aware that she can't talk to you about this case.
yes.
I'm just, one other question, do you have any concerns that if you reach a verdict different than your wife's opinion, that will cause any problems? I don't have any other questions, Your Honor.
All right, thank you, Mr. Pryor.
I've got so many areas I could go into about the interrelationship between a husband and a wife. And you know what I mean? You folks have been married a long time, every 2 years. And congratulations. That's impressive in this day and age. You've been married longer than a lot of these younger folks in this room have been around. I am always concerned, and it doesn't mean anything, it's just a concern that I want to bring up. I'm always concerned when someone says, I'm not going to talk to my partner or significant other about something that's involved in their life, something that's important. Would you share with me that this is an important task that you might be assigned?
Yes, it absolutely is.
And I'm only hesitating a bit here. And I'm only hesitating because I'm the length that you two have been together. At a certain point in your life, you get to the point where a couple literally become one. You know what I'm talking about?
Yeah, absolutely. Absolutely, and I believe that.
Yeah, my wonderful mother and my father, who's no longer here, were married well over 50 years before my father's passing. And it was almost like talking to one person at the end, because they've come so close and they developed such a strong relationship. And then the reason I'm bringing this up is that's what's causing me pause here.
Yeah.
And could you recognize that could potentially be a problem?
I recognize that the perception is there. The difference is we both have different upbringings.
Okay.
And in 40, I have to correct myself, 43 years of marriage. I know her and I know her really well. And I know her biases versus mine.
Okay.
And so they differ. So while we raise our children the same, we are one in general principles, we do have our own individual opinions and our own individual insights and backgrounds. I live in the business world, and the business world is far different than being in the home. I'm not saying it's worse or better, I'm just saying it's different. And so you learn business politics, you learn what you're doing. In my case, I'm representing county and the people, not necessarily myself.
Okay.
That makes sense to you? I see it as a civic duty and the opinion to keeping my own personal biases to myself, and they don't persuade my decision.
Okay. And just one clarification, when you say the county that you represent, who are you referring to?
Well, I mean, I'm sitting in a jury and paneled on a jury, and the jury happens to be Ada County, but we're representing another county. You guys are from different counties, but the laws are still there. The rules are still there, and so I'm being a representative of that, and I take my civic duties seriously.
Okay, and I share the same county, by the way, with you. That's a different topic, but you know what, Judge, I think that his explanation is I really appreciate it. I really do. And, I think I'm going to pass it this, Judge. Thank you.
All right. Juror number 1779, there's another area we'll discuss, and that is relating to your attitudes regarding the death penalty. When you completed your questionnaire last week, you were provided questions about that and answered those. Do you recall answering those questions?
Yes.
As you sit here today, do you believe those answers still accurately represent the way you feel about it?
Yeah, I believe so. I haven't changed my opinion. Maybe I misread something, but no, as far as I.
And to be clear, I'm not trying to set you up for
Yeah,
something
no,
wrong. I'm just saying.
I understand that.
You've now thought about it, and importantly, when you fill out the questionnaire, it's more of a hypothetical type question, perhaps. In this case, though, and at this time, I am advising you that it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty in this case. So when you consider any penalty, consider it as if it should, you need to consider that as if it is absolute and will be carried out in the case. So with that in mind, you indicated in your questionnaire that you support the death penalty when you have this option of support or oppose. Is that correct?
Yeah, I support that we as a people have decided that that's a penalty that may be applied, and I support that decision. And I'm willing to support that as one of the options.
Okay. You selected a choice describing what most accurately represents the way you feel that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel as you sit here today?
Yeah, there isn't really a neutral. So what I would say is that, yes, I support it and I fully support it because that's a decision that's been made based on law and what we have in the laws of the state. And I'm going to support that and make decisions accordingly, assuming the instructions are clear and that I know we as a jury can make that as fact.
Okay. Let me ask you this then. Are you in favor of the death penalty in every case where a murder has been committed?
No, I don't. I qualify it because I don't know what the law is. I qualify it where it's applicable to law, yes. I don't know that it's applicable in all cases. So I don't know that because I'm not a lawyer and I don't know what the rules are. I'm hoping you'll tell me.
I'll do my best.
Thank you.
Going back to your answer then, you said you would follow the instructions in the case relating to the death penalty, and that's correct?
Yes.
All right, finally then, is there anything you think about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror in this case?
No.
All right, the court's concluded with its order questioning on the topic. Does the state have any questions?
No.
Any questions from the defense?
I've brought this up, sir, a couple of other times with a couple other prospective jurors and do you have your questionnaire with you?
Do.
If I could ask you to turn to page 13 of your questionnaire. Okay. And you marked item number C or C, is that correct?
Yes.
And then underneath that is an item number D. And the difference is one says oppose, one says in favor. Do you recognize that?
Correct.
And I think when you talked about neutral, you said that you felt that, and I've asked other jurors this, that if there was a box between C and D that said neutral, and I'm just going to apply the facts and make a fair determination, would that be where you fit?
Yeah, I believe so.
Okay, Judge, I have nothing else. Thank you, sir. Thank you.
All right, thank you for coming back. We'll talk to you again after we finish talking to the other jurors and give you further instructions. Next up will be juror number 8-4. All right, thank you, juror number 8-4 for returning for individual voir dire at this time. Counsel, I didn't see any indication that we needed to do more voir dire concerning bias or hardship. Does the state have any questions on that?
We do not, Your Honor. No questions, Your Honor. Thank you.
Okay, so juror number 8-4, then there's one other area we'll discuss with you, and that relates to this part of your questionnaire and your attitudes regarding the death penalty. So when you were here last week, you filled that questionnaire out and went through that section. Do you recall that?
Yes,
Have your attitudes regarding the death penalty changed since you filled out the questionnaire?
no,
Okay, in your questionnaire, you said that you opposed the death penalty when you had the choice of support or oppose. Is that correct?
that's correct.
All right, I do want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. In the questionnaire where you had choices about what would most accurately describe the way you feel about the death penalty, you selected an option that reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Does that still accurately represent how you feel about the death penalty?
It does.
All right. Would you be in favor of the death penalty in every case where a murder has been committed?
Respectfully, I'm not a judge, and so I don't know what the difference between a case that warrants the death penalty is and a case that doesn't warrant the death penalty is.
Okay, and you did indicate that you are generally opposed, but you would follow instructions that the court provided, even if you felt opposed to it, and still be able to follow those instructions. Is that correct?
That's correct.
And that would include considering imposing the death penalty if that's what the law instructed.
Correct.
Okay, is there anything about your views on the death penalty you think that could prevent or substantially impair your ability to serve as a juror in this case where that may be considered?
No.
All right, that concludes the court's voir dire questioning of juror number 8-4. Does the state have any questions?
Your Honor, we do not.
No questions, Judge. Thank you.
Okay, thank you, juror 8-4. We'll have you return to the jury room and we'll talk to our next juror. That will be juror 126. One, two, six. Does the state intend to have any voir dire in terms of bias or hardship for this juror?
No, thank you, Your Honor.
Mr. Pryor, do you know if you'll have any on that?
Judge, there may be some inquiry that may require a closed.
All right. All right, thank you for returning juror number 126. We have some additional questions for you. I inquired on the state if there was any bias or hardship voir dire. They indicated there was not. Mr. Pryor, you indicated you may want to take up some topic within the questionnaire outside of the public view. Is that correct?
Yes.
May I have just a quick sidebar with counsel? All right, thank you, counsel. The court in a sidebar has discussed with attorneys some topics that we are going to be dealing with on the remaining jurors in this group that are going to be private matters, so we are going to take those up on the record. However, we're going to close the public proceeding for that in order to discuss a few different topics that can't be discussed in public. So at this time, juror number 229, right?
120.
I'm sorry, 126. We will have you just remain there seated for a moment, and I'm going to have the public cease from the courtroom and cease the broadcast at this time, still remaining on the record for the questioning of this juror.
folks, as you walk in, we did have property on the private hearing. So just take a peek and make sure your property is in this hallway. Rather than bring it. Steps up, so we had to sweep out some property on this wall. Double check if the stuff is all.
That's an option.
Folks, new trial, so, we were kind of starting from ground zero. Everything forward, and you take breaks. All right, please.
Thank you. Please be seated. All right, ladies and gentlemen of this jury panel that are remaining, if you would do us a favor again, and please hold up your red cards so we can confirm who is here. All right, thank you. And we are back on the record on CR 22-21-1623, continuing the jury voir dire process. With these remaining jurors, I'm going to ask the state now, does the state pass this small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this small group for cause?
Yes, Your Honor, thank you.
All right, ladies and gentlemen of the jury, you have been passed for cause. We'll continue to question additional small groups if necessary until we reach enough jurors to have the attorneys exercise their peremptory challenges. You'll be instructed to contact the jury commissioner, Randy Rutland, in order to receive further instructions regarding when you're going to be required to return. I will announce at this point to counsel and the jurors that is likely to be Monday morning. We will get a specific time and confirmation. So as you're looking at planning to come back, I'm fairly confident that's when you'll be returning to the court along with other jurors for peremptory challenges. Between now and then, please do not do anything to investigate the case, follow the case, or discuss the case amongst yourselves or with anyone else. We've done a lot of work to get jurors that we believe are impartial and unbiased without case knowledge. If this is in the news and you see it in passing, please try to avoid that. Don't talk about the facts of it with anyone, or of course, do any research. We'll have you sign an affirmation when you return, confirming that you have followed that important instruction. And you are, however, of course, allowed to discuss when you may be serving and your commitment in order to make arrangements with your personal schedules. So at this time, then, that will conclude the voir dire for this group of jurors. Does the state have anything further before they're released?
No, Your Honor, thank you.
From the defense?
No, Your Honor, thank you.
All right, ladies and gentlemen, please rise for this jury panel.
All right, please. You folks come back with questions. Right on your job.
Thank you. Please be seated. May I have a sidebar with counsel, please?
Mr. Court is now back in session.
Thank you. Please be seated. All right, council, we're back on the record now. We have secured enough jurors for the exercise of peremptory challenges. We will plan on that occurring Monday morning. The court went through a rough outline of scheduling moving forward, but we will reconvene at, unless otherwise noted, at 10 o'clock on Monday for the peremptory challenges. And if the parties have any other court business or matters to take up before 10 o'clock, we can do that Monday as well. For today, then, I believe that concludes the court's businesses on the case. Is there anything further from the state that we would wish to put on the record for this afternoon?
Not from the state, Your Honor. Thank you.
Nothing further, Judge. Thank you.
All right, thanks, council. We'll be in recess until Monday.